Michael Popok, Legal AF. I want to talk about the differences between what Donald Trump just did in state court in his civil fraud case and what he is and is not going to be able to get away with in his federal court criminal cases, nor in Fulton County, Georgia, in a state court case. Let's talk about the differences here on my hot take on Donald Trump in the courtroom. What we saw during the civil fraud case and have seen is that since there's no jury present, Trump and his family are taking full advantage of it. Usually when there is or almost exclusively when there is a jury as the fact finder making decisions about the case, decorum must be maintained by the judge. Otherwise, it will influence the jury. Outbursts, storming out of the courtroom, berating people and the judge and the staff in front of a jury is not tolerated in the way that it's being currently tolerated by Judge Engoron. Even there, Judge Engoron, of course, has taken steps to protect his staff and has gagged Donald Trump's lawyers and Donald Trump and fined him twice. However, he has given him a tremendous amount of latitude, both in courtroom behavior and conduct that would never be tolerated in front of a jury, ever, even by Judge Engoron here, even giving Donald Trump a lot of latitude to avoid appellate issues. The more Donald Trump talks uninterrupted, although it's frustrating the judge, as the trier of fact to get to the bottom of the facts, it does take the wind out of the sail of Donald Trump to argue that he wasn't given a fair trial or due process because he's just talking at length, as are his children, without any connection to the question that's being asked. That's on them. But let's back to decorum. Things that are happening and we've observed and we've reported on here on the MeidasTouch network, such as Donald Trump getting frustrated during Michael Cohen's testimony and storming out of the room with his Secret Service running behind him, is not going to happen in federal court during a jury trial for a number of reasons. Things that we also observed in the Engoron state court proceeding, like impromptu press conferences, Donald Trump holding court with press outside the courtroom, Donald Trump coming back late from breaks in order to answer questions from, softball right-wing media. That's not going to happen in federal court, I assure you, for a number of very good reasons. First of all, in federal court, as we now know, there is no ability to have cameras in or near the courtroom. There's no cameras in or near the courtroom, and there's no ability for the press to conduct interviews, impromptu or otherwise, of Donald Trump. The federal marshals and the bailiffs and the deputies will quickly break up any attempt by Donald Trump to hold court, if you will, outside the courtroom, answer questions, hold a press conference, make statements in real time about the case. He's going to be effectively gagged, not by gag rules per se, but by procedure. So there's not going to be any cameras inside, outside, or even near the courthouse. He's going to have to end his trial day, Donald Trump, go outside at the end of a day and hold a press conference at 5 or 6 o'clock at night if he dares. Now, the other aspect of this is there'll be a jury in the two federal criminal prosecution cases, Mar-a-Lago in Florida and, of course, in the D.C. election interference case. And because there's a jury present, neither judge is going to allow the outbursts, the berating, the failure to follow simple questions, the failure to respond to questions that Donald Trump has been exhibiting. It's just not going to happen in front of a jury. He'll be found, and it won't be gagged, he'll just be barred from his own courtroom. He'll be told that he can't participate in this process because of his outbursts, which Judge Engoron almost did. They'll find negative or adverse inferences against him, and they'll instruct the jury to take those outbursts as in an adverse way against the defendant. I don't know if Donald Trump's lawyers have any kind of control over him. They don't appear to. And I'm talking about Alina Habba and Chris Kice so far in the civil case. Even if you add Todd Blanche and John Lauro, I think the four of them can't pin Donald Trump down in front of a jury. If he acts out in front of a federal judge, he will find himself in contempt. If he acts out again, he'll find himself in criminal contempt, and he could either be put into custody or just be barred from his own trial. Has a tremendous impact on due process rights, but Donald Trump will invite it by his own conduct. They will not, to make it clear, a federal judge is not going to allow a jury to be influenced or swayed or intimidated by Donald Trump's outbursts. His storming out of the courtroom is not going to happen. In all of his criminal cases, he needs to be there as it's required to be there without be given any break or special disposition for every day of his criminal trials, every day. He's not going to be able to come and go as he please and bring, as Letitia James, the New York Attorney General, used to call it, the Trump circus is back in town. There'll be no Trump circus in terms of him coming and going and picking and choosing which days he'll need to be there. He will need to sit in that chair for the entire D.C. election trial. And let's say that goes 6 weeks. He won't be campaigning during those 6 weeks, during the day anyway. Same thing in Fort Pierce. He'll have to sit in his chair in Fort Pierce for the Mar-a-Lago case, and the same thing in the state court. I haven't talked much yet, but I will now about the state court proceeding. State court proceedings a little bit different because Judge McAfee's already made it clear he is going to televise his case, his trial. He's televised everything leading into it, all the proceedings and arraignments and sentencings. He does it by YouTube. We were able to comment on it here on the MeidasTouch network. But I don't believe he's going to allow Donald Trump to hold press conferences in the hallway, come back late to court, and anything like that. And again, we have the disciplining function or component of the jury present, that this Judge McAfee, who's to now, we've been very impressed with him, straight shooter, runs a tight courtroom, tight courthouse. I don't believe he's going to allow Donald Trump to act out and push the limits in front of a jury. It's one thing to abuse a judge and a law clerk or staff, which is always a dangerous place to be as a lawyer or as a client. I've been doing this for 32 years. I've never seen at all what's going on in the courtroom with Donald Trump be tolerated as much as it is. But a criminal case in front of a jury, you respect the jury, federal or state, in the United States process. There's a reason we rise for the jury. We rise for the judge, but we rise for the jury. There's a reason for that in their role in our criminal justice system and in our system of due process. They are an honored participant in the process and an important one in our system of jurisprudence. And so they get respect, and they are afforded respect and protection. They're going to be anonymous in Georgia. They're going to be anonymous in another case involving Donald Trump, involving E. Jean Carroll that goes to trial in January. I don't know yet about the anonymity of the juries in the federal criminal cases, but that'll be determined on an as-needed basis. But the jury is an entity that garners respect and commands respect, and if it doesn't come naturally, it'll come by force and compulsion by the judge and by the federal marshals and others in the room, Secret Service notwithstanding. Donald Trump is not going to be able to abuse the jury or just get frustrated at some testimony and run out of the room and have the Secret Service run behind him in a federal criminal case or even a state case. So the only big difference between the criminal case and the state case, and the criminal case will go first. We have a March 2024 case in front of Judge Chutkan on the D.C. election interference case with one defendant, of course, Donald Trump, for conspiracies. There won't be any cameras, and there will be a jury. And we will observe his conduct and his behavior. And if his lawyers can't get him under control, I assure you Judge Chutkan will rapidly get Donald Trump under control, as only a federal judge wearing a black robe with staff can do. So I don't want people to worry, and I want to manage expectations where they think this is going to be Donald Trump's MO in his criminal cases, because, history is often prologue. Not here. Not here. We've been watching sort of an S show go down in the New York Supreme Court, where I regularly practice, including in this particular courtroom, mainly because Engoron is bending over backwards to give him that latitude to avoid appellate issues and because there's no jury present. This would be a horse of a different color if there was a jury present and the judge had to also protect them from abusive acting out conduct by Donald Trump. For now, it's just playing to the advantage of Letitia James, the New York Attorney General, because it's making Trump unstable and destabilized, and he says dumb things and confessions on the stand during his testimony, as did his children, and as the New York Attorney General's lawyers just methodically chop wood and stack wood every day, presenting evidence. The slow, methodical presentation of evidence and witnesses is what's really going on in the courtroom, although the press likes to report on all the shiny object outbursts by Donald Trump and his family and Eric Trump and Alina Habba and everybody else, because I guess it's more interesting and it sells more newspapers and it brings more viewers to their content. But what's going on from a legal standpoint, and that's what we talk about always on Legal AF on the MeidasTouch network, is we're observing as, I'm a 32-year trial lawyer, what is really going on? How is the evidence going? Is there any evidence so far presented that helps Donald Trump's case? Short answer to that is no. But join us on Wednesdays and Saturdays at 8 p.m. for the Legal AF podcast, only on the MeidasTouch network, where we do exactly what I'm doing here, but I've got a co-anchor on Wednesdays, a longtime 30-year prosecutor named Karen Freeman-Agnifilo, Ben Meiselas on Saturdays. And this is what we do. We don't blow smoke or sunshine. The leaders of Legal AF bring our 75 years of collective experience to each issue, and we give it to you straight with our own analysis because we practice in courthouses and courtrooms and in cases just like the ones we're talking about now. If you like this particular hot take, give me a thumbs up. And then join us on the Legal AF podcast. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.